Welcome back to Enchanted Learning. It's me, Banasar Khalid. You studied your last class portions. Do you have any doubts? Now today we are going to study a new topic. Are they caught? Umbrellas can't stop rain, but it can make us stand in rain. Confidence may not bring success, but it gives us the power to face any challenges in life. Please examine the quote. That is, umbrellas can't stop rain, but it can make us stand in rain. Likewise, confidence may not bring success, but it helps or it gives us the power to face any difficulties or any challenges in the life. And thus, we can attain success. So, moving to the topic citizenship. Before that, may I ask some questions related to directive principles of state policy. First question, which commission recommended the directive principles of state policy in Indian Constitution? That is, Subpro Committee. Subpro Committee recommended the directive principles of state policy in Indian Constitution. Next question, which constitution part includes the Gandhi's idea of welfare state? Which constitutional part includes the Gandhi's idea of welfare state? That is part 4, directive principles of state policy. Now mention the article which were adopted to directive principles of state policy as per 42nd Amendment Act of 1976. So I will mention those articles which were added to directive principles of state policy as per the 42nd Amendment Act of 1976. These are the articles. Please note down. Article 39. May I remember you one thing. These points are very. While considering or while providing this class to you, I have verified the content related the special those topics of Constitution from Lakshmi Kant's Indian Polity. I have referred those points from the Lakshmi Kant's Indian Polity. So you have to note these points as these points were taken from Lakshmi Kant's Indian Polity. So Lakshmi Kant's Indian Polity, there the articles which are added to directive principles of state policies. Which are those articles added to directive principles of state policy as per the 42nd Amendment Act of 1976? Please note that I have, while providing this class to you all, I have referred certain points which were published in Lakshmi Kant's Indian Polity, and so you have to note those points as it will be very useful for upcoming exams. So write down the points as I am mentioning those articles, etc. So what the question we are discussing about? Which is the article which were added to directive principles of state policy as per 42nd Amendment Act of 1976? Note those articles. Article 39. Article 39, it is to provide it is to secure opportunities for healthy development of students. So Article 39, that is to secure opportunities for healthy development of children. That is Article 39. It was introduced to Directive Principles of State Policy as per the 42nd Amendment Act of 1976. And Article 39A, that is to promote equal justice and to provide free legal aid to poor. That it takes necessary steps to secure the participation of workers in the manufacturing industries. That is Article 43A. And 48A, to protect and improve the environment and to safeguard forests and wildlife. So these are the articles which are included in the Directive Principles of State Policy as per the 42nd Amendment Act of 1976. That is Article 39, Article 39A, Article 43A and Article 48A. And which is the article that is added to the Directive Principles of State Policy as per 44th Amendment Act of 1978? That is Article 38. Article 38. It requires the state to minimize inequalities in income, status, facilities and opportunities. It requires the state to minimize the inequalities in income, status, facilities and opportunities. It is Article 38. It is introduced to new directive principle state policy as per 44th Amendment Act of 1978. Now, we have also studied that the 86th Amendment Act of 2002, that is Article 45, made elementary education a fundamental right under Article 21A. And as per the 96th Amendment Act of 2011, as per the 97th Amendment Act of 2011, another article was introduced to the directive principle state policy, that is Article 43B. Article 43B. As per this article, the directive principles of state policies, this article relates to cooperative societies. It is provided, or it requires the state to promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative societies. So, as per the article, as per the 97th Amendment Act of 2011, a new article was introduced to the directive principle state policy, that is Article 43B. It is related to cooperative societies. That is, the state is requires to promote the voluntary organization, formation, autonomous functioning, democratic control and professional management of cooperative societies. That is introduced the directive principle state policies as per the 97th Amendment Act of 2011. 97th Amendment Act of 2011. Please note these articles and the amendments. So now moving to the next topic, that is citizenship. So citizenship, that is Article 5 to Article 11 deals with citizenship. Before that, we can know from where the Constitution adopted the idea of citizenship, etc. Moving to the topic citizenship, like any other modern state, India has also two kinds of people, that is citizens and aliens. The citizens are full members of Indian society, so they enjoy all the civil and political rights. Citizens are the full members of the Indian state and they enjoy almost all political and civil rights. And as we are considering, the Constitution confers rights and privileges on the citizen of India. That is Article 15, Article 16, Article 19, Article 29, 30. These are the fundamental rights which are provided to Indian citizens. So those fundamental rights, this Article 15, Article 16, Article 19 and Article 29 and 30, those are the fundamental rights providing to Indian citizens. And other rights which included to Indian citizens are a right to vote in elections to the Lok Sabha and State Legislative Assembly. So every Indian citizen has a right to vote in Lok Sabha as well as the State Legislative Assemblies. Next right, that is to contest for the membership of Parliament and the State Legislature. They can vote. They have the right to vote in elections as well as to contest for the membership of Parliament as well as State Legislature. And another right, that is eligibility to hold certain public offices, that is President of India, Vice President of India, Judges of Supreme Court and High Courts, Governors of States, Attorney General of India and Advocate General of States. And these also have the citizens have the eligibility to hold certain public offices, that is President of India, Vice President of India, Judges of Supreme Court and High Court, Governor of States, Attorney General of India and Advocate General of States. So all the above rights, the citizens also have certain duties towards the Indian state that we have already studied. So as we are considering the citizenship, the Indian citizens have the following rights. Those fundamental rights belong to Indian citizens are Article 15, 16, 19, 29 and 30. Along with certain other rights also is provided, that is right to vote in elections to Lok Sabha as well as state legislatures. Or another right is to as vote as well as to contest for the membership of parliament and the state legislatures. Next one, it provides is right is every citizen is eligible to hold certain public offices, that is President of India, Vice President of India, Judges Supreme Court, High Courts, as well as Governors of State, Attorney General of India, Advocate General of State, etc. So now, in India, both a citizen by birth as well as a naturalized citizen are eligible for the office of President, while in USA, only citizen by birth and not a natural citizen eligible for the office of President. We can understand more about this while considering different types of how a citizenship is provided to a people in a country. That is, for example, we are studying Indian citizenship. Now moving to the constitutional provisions. That is, Constitution deals citizenship from Article 5 to 11 under Part 2. So Article 5 to 11. 5 to 11, that is Part 2 of Indian Constitution. So Article 5 to 11 of Part 2 of Indian Constitution deals with citizenship. It only identifies the persons who became citizens of India at its commencement. That is, it only identifies the persons who became citizens of India at its commencement. That is, at the commencement of this Constitution, that is 26 January 1950. Only at that particular date, only after that particular date, that is before or after the particular date, that person is considered to be a citizen. Only though the persons who became citizens of India at its commencement. That is what mentioned in Constitution. And according to the Indian Constitution, citizenship is provided, or before that we have to know this is the Citizenship Act of 1950. So we understood the fact that is the Constitution deals with Indian citizenship as per that is from Article 5 to 11 of Part 2 of Indian Constitution. That is, this Constitution the Part 2 of Indian Constitution deals with Article 5 to 11, and that is dealing with citizenship. Article 5 to 11 deals with citizenship, which is placed in the Part 2 of Indian Constitution. And before that, you also understood that those persons are considered Indian citizens who were identified as Indian citizens at the time of its commencement of the particular constitution, that is 26 January 1950. And now we are going to know more about the Citizenship Act. This particular Citizenship Act, which was passed in 1955, provides for acquisition as well as loss of citizenship after the commencement of the constitution. So 1955 Citizenship Act provides for what purpose? For acquisition as well as for the loss of citizenship after the commencement of the constitution. So this Citizenship Act was provided for acquisition as well as a loss of citizenship after the commencement of constitution. That is, the Citizenship Act 1955 is provided for what purpose? For acquisition as well as loss of citizenship, that is after the commencement of Indian Constitution. First, acquisition of citizenship. How can a citizenship be acquired by a citizen? That is, in India, the Citizenship Act of 1955 prescribes 5 ways of acquiring citizenship. So, a citizenship can be acquired by means of 5 ways. Which are the 5 ways? So, Indian citizenship can be acquired by means of by birth, by descent, by registration, by naturalization, and by incorporation of territories. So, Indian citizenship, that is, it can be acquired by Citizenship Act of 1945. The Citizenship Act of 1955 provides 5 ways of acquiring citizenship. That means by birth, by descent, by registration, by naturalization, and by incorporation of territories. So, we understood that Indian Constitution provides citizenship, and that article is from 5 to 11, and it is described in Part 2 of Indian Constitution. And we also understood that it only identifies the person who became the citizens at the commencement of the Constitution, that is on January 26, 1950, and it also empowers the Parliament to enact a law to provide any matters relating to citizenship. So the Parliament has the authority to make laws, that is the matters regarding the citizenship. Parliament is have empowered the power, or Parliament has the power to make laws with concerning the citizenship of India. And now we are discussing different types of citizenship. That is, citizenship can be acquired by what all means: by birth, by descent, by registration, by naturalization, by incorporation of territories. We can see one by one. First one is by birth. As per Citizenship Act of 1955, first way of acquiring citizenship is by birth. That is, a person born in India on or after January 26, 1950, but before July 1, 1987, is a citizen of India by birth, irrespective of the nationality of his parents. That means, a person born in India on or after January 26, 1950, but before July 1st, 1987. If a person is born on that particular date, January 26, 1950, or after that, but before July 1st, 1987, he is considered as a citizen by birth, irrespective of nationality of his parents. That is, without considering the nationality of his parents, a person is said to be a citizen of India if he is born on or after January 26, 1950, but before July 1st, 1987. That is one fact. Second one, a person born in India on or after July 1st, 1987 is considered a citizen of India only if either of his parents is citizen of India at the time of his birth. So we have told in this Constitution what is provided in the Citizenship Act of 1955. That is, by birth a person acquires citizenship only if he is born on or before January 26, 1950 or before 1st July 1987, and that is without considering the nationality of the parents, it is said so. In the second case, if a person is born in India after July 1st, 1987, he can be considered citizen only if either of his parents are citizens of India at the time of his birth. That is the second condition. And the third one is, those born in India on or after December 3rd, 2004 are considered citizens of India only if both of their parents are citizens of India, or whose parents are citizens of India, other is not an illegal migrant at the time of their birth. In the third condition, those born in India on or after December 3rd, 2024. That is, those born in India after December 3rd, 2024, they can be considered citizens of India only if both of their parents are citizens of India, or one of whose parents is a citizen of India and other is not an illegal migrant of the time, illegal migrant at the time of their birth. In the third case, if the citizen is born on December 3rd on or after December 3rd, 2004, if a citizen is born on or before December 3rd, 2004, then he can be considered citizen only if both of his parents are citizens of India, or one of his parents is a citizen and other is not an illegal migrant at the time of his birth. That is a third condition. So, by birth, a person is said to be an Indian citizen if he is born on or before January 26, 1950, and also consider the other day, that is before 1st July 1987. Then he can be considered citizen of India without considering his parents' nationality. In the second case, if he is born on after July 1st, 1987, he can be considered Indian citizen by considering both the nationality of the parents. Considering either of his parents are citizens of India at the time of his birth. And considering the third point, if a citizen is born on or after December 3rd, 2004, he can be considered citizen if both of his parents are Indian citizens, or if one is an Indian citizen and other is not an illegal migrant at the time of his birth. That is what discussed in acquiring Indian citizenship by means of birth. Hope you have understood. Next one, by descent. By descent, how is a person acquiring citizenship by descent? That is, a person born outside India on or after January 26, 1950, but before December 10, 1992 is a citizen of India by descent if his father was citizen of India at the time of his birth. Here also, you have to understand that if a person is born outside India or on or after January 26, 1950, but before December 10, 1992, is a citizen of India by descent if his father is citizen of India at the time of his birth. First condition we told that the person is born in India itself. In the second condition, by descent means if a person is born outside India. By descent means if a person is born outside India on or before January 26, 1950, but before December 10, 1992, he can be considered Indian citizen by descent if his father was a citizen of India at the time of his birth. Now that point. The second case, if he is born on after December 10, 1992, he can be considered citizen of India if either of his parents is citizen of India at the time of his birth. Understood? He can be considered citizen of India if he is born on or before December 3rd, 1992. He can be considered citizen of India if either of his parents are citizens of India at the time of his birth. And December 3rd, 2004 onwards, a person born outside shall not be considered citizen of India by descent unless his birth is registered at an Indian consulate within 1 year of date of birth or with the permission of central government after the expiry of said period. So, not the point, by descent, a person cannot acquire citizenship when he is born December 3rd, 2004. When he is born December 3rd, 2004, when the person is born outside India, he shall not be considered citizen of India by descent. He can't attain citizenship by descent because unless his birth is registered at an Indian consulate within period of 1 year at the date of birth, or within a period of 1 year of date of birth, or with the permission of central government after the expiry of the said period. So he can be considered citizen only if he has registered, only if his birth is registered at an Indian consulate within 1 year of period of its 1 year of date of birth, or with the permission of central government after the expiry of the said period. So that is what mentioned in by descent. So here you have to just remember the points. By descent, a person can acquire citizenship. By descent means a person is born outside India. That is outside India on or before particular date January 26, 1950, but before December 10, 1992. He can be considered citizen by descent if his father is a citizen of India at the time of his birth. In the second case, if a person is born outside India on and after December 10, 1992, he can be considered citizen of India if either of his parents is citizen of India at the time of this birth. And the third condition, on December 3rd, 2004, if a person is born outside India, he shall not be considered citizen by descent unless his birth is registered at an Indian consulate within 1 year of period of date of birth or with the permission of central government within the concern after the expiry of the said period. Have you understood? So that is the two means of acquiring citizenship. That means by birth as well as by descent. By birth, a person acquires citizenship when he is born on or before January 26, 1950, but before 1st July 1987, he can be considered citizen of India, irrespective of his nationality of his parents, irrespective of the nationality of his parents. And the second case, if he is born on after July 1st, 1987, he can be considered citizen if only either of his parents is citizen of India at the time of his birth. And third condition, if he is born on after December 3rd, 2004, he can be considered citizen only both of his parents are Indian citizens or one of his parents is citizen of India and other is not an illegal migrant at the time of his birth. And by descent, a person acquires citizenship. How? That is when a person is born outside India on or before January 26, 1950, but before December 10, 1992. Here the dates are different. If a person born outside on on or after January 26, 1950 or before December 10, 1992, he can be considered citizen of India by descent if his father is a citizen of India at the time of his birth. And the second case, a person born outside on after December 10, 1992 is considered citizen of India if either of his parents is citizen of India at the time of his birth. First case, by descent, he acquires citizenship when he is born on a particular date, January 1950. Outside India, when he is born outside India on a particular date, January 26, 1950, he can be considered citizen by descent if his father is citizen of India at the time of his birth. But if he is born after December 10, 1992, he can be considered citizen of India if either of his parents is citizen of India at the time of his birth. And December 3rd, 2004, if he is born outside India on December 3rd, 2004, he can not be considered citizen of India unless his birth is registered on Indian consulate within 1 year of period of date of birth or with the permission of the central government before the expiry of the said period. Have you understood? Next one is by registration. That is, the central government may on application register a citizen of India of any person by if he belongs to such following categories. It is a central government may on an application register as a citizen of India any person if he belongs to any of the following categories. If he is not an illegal migrant, he can be considered as a Indian citizen by means of registration. That is, the central government may on an application register as a citizen of India any person if he belongs to any of the following categories. Which are the following categories? A person of Indian origin who is ordinarily resident in India for 7 years before making an application for registration. A person of Indian origin who is ordinarily resident in India for 7 years before making an application for registration. Second one, a person of Indian origin who is ordinarily resident in any country or place outside undivided India. First case, if a person of Indian origin who is ordinarily resident in India for 7 years before making an application for registration, and a person of Indian origin who is ordinarily resident in any country or place outside undivided India. These persons can be given citizenship by means of registration. A person who is married to a citizen of India and is ordinarily resident in India for 7 years before making an application for registration. Then another case, that is minor children of persons who are citizens of India. Minor children of persons who are citizens of India. Then a person of full latent capacity whose parents are registered as citizens of India. So as we are considering following criteria, we can the Constitution here, as per the Citizenship Act 1955, the Citizenship Act of 1955 provides citizenship by means of registration. That is, the central government may on an application register a citizen of India as per considering the following criteria. Next one, by naturalization. Here is a naturalization. Naturalization means the central government may on any application grant a certificate of naturalization to any person if he possesses the following qualifications. That is, if he is not a subject of citizen of any country, but citizen of India proven to become a subject citizen of that country by naturalization. That he has either resided in India or been in the service of government in India or partly the one or partly the other throughout the period of 12 months immediately preceding the date of application. So in this case, by naturalization, how can be citizenship acquired by naturalization? We have mentioned that Indian citizenship can be provided by means of registration. So that is, the central government by an application may register a person a citizen of India. By means of this method, by registration, Sonia Gandhi got citizenship of India. Indian citizenship was received by Sonia Gandhi by means of registration. Then it's by naturalization. That is, if a person is a central government may on application grant a certificate of naturalization to any person if he possesses the following qualification. That is, if he has been living here for a period of 12 months, or if he has been resided in India or being in the service of government of India, and if he is of good character, if he is an adequate knowledge of language specified in the 8th schedule of Indian Constitution, That means if he is residing here for a long purpose and if he is of good character, a person can be given Indian citizenship. And that person who got such citizenship by means of naturalization was Mother Teresa. Mother Teresa, the Nobel Prize winner and Bharat Ratna laureate, Mother Teresa got citizenship of India as by means of naturalization. The next one is by incorporation of territory. By incorporation of territory also, Indian citizenship is received by a person. That is, if any foreign territory becomes a part of India, the government of India specifies the persons who among the people of the territory shall be the citizens of India. That means if any foreign territory becomes a part of India, government of India specifies those persons who among the following among the people of that particular territory shall be the citizens of India. That is, if a foreign territory becomes a part of India, then government of India has authority. Now he has a power to specify those specifies the people of that particular territory to be the Indian citizens of India. Such persons become citizens of India from the notified date. For example, when Pondicherry became a part of India, the government of India issued a citizenship order, that is 1962, under the Citizenship Act of 1955. So that is, for example, when Pondicherry became a part of India, the government of India issued the citizenship order, that 1962, under the Citizenship Act of 1955. So these are the following these are the following ways a citizen acquires Indian citizenship by means of as per the Citizenship Act of 1955. As per the Citizenship Act of 1955, a person acquires Indian citizenship by means of birth, by means of descent, by means of registration, by means of naturalization, and by means of naturalization as well as by means of incorporation of territories. These are the means of receiving for acquiring Indian citizenship. That is under this Indian Citizenship Act of 1955. Under the Citizenship Act of 1955, we have studied how a citizen can acquire Indian citizenship. So these are the methods by means a citizen acquires Indian citizenship. So today in this class we have just completed a half portion of the Indian citizenship, the topic citizenship, and the remaining part will be complete on next class. Hope you have understood the class. If so, please subscribe. Keep watching. Till then, it's bye from me. Thank you.